information security architect from Silvery LLC from Ukraine. Also, Darina Grebenyuk, who is associate from Artsinger, specializing in alternative dispute resolutions and international arbitration matters. Also, Mr. Vasil Poptasov, which his counsel in the field of IP and IT law here in Ukraine. Also, Mr. Paul Glass, who is commercial and technology and data group leader from the UK. Also, Mr. Otto Slikin, who is a partner on IP and IT group in the Netherlands. Mr. Andreas Schulz, who is a partner in IP and IT, as well as environmental and regulatory group in Austria. Mr. Paul Voigt, who is a partner of technology, media, and telecom practice from Tellerwesen from Germany, and Mrs. Valerie Omage, who is head of IT and data protection and privacy group from France, also from Tellerwesen. So I really appreciate your participation in this meeting, my colleagues from Artsinger, from Silvery, and from Tellerwesen, and all the other participants and members of our working group from the other Ukrainian companies who participate on a permanent basis too. So the main idea of this meeting is to share experience on use of telecom, especially video conferences in daily business, courts, and in some corporate governance events here in Ukraine and in a number of jurisdictions, not only because of the pandemic time, but because of the boost of technologies and the use of more convenient tools for communication. Okay, I would really appreciate if we have a discussion in the format of fireside chat. So don't feel free and don't hesitate to ask your questions and to share your minds on the matter will be discussed. Everyone has its microphones turned on, so please you feel free to join the discussion and even slightly to interrupt each other. Yeah, we'll have to have as much productive discussion as we can. Okay. So let's start with some technical point of view on telecom matters and the use of some video technologies for operation of business here in Ukraine and and abroad. So I give the floor to Anna Papirna, who is the information security architect in Silvery company here in Ukraine. So, please ask.
Thank you, Tanya. Hello, dear colleagues. Today I will cover the first part of our online discussion, which relates to the technical aspects of organizing secure communication, including video conferencing. And I want to start with a presentation of IT company I work in. And Silvery is a system integrator with a team of professionals with over 10 years of experience in IT and information security fields.
Could you please switch on your camera? It would be easier if we see you.
Oh, well, these slides are more important than my face. I think I will get back to you after I finish. Yeah, okay.
Okay.
Okay. So what we offer? We offer the design of integrated turnkey information security systems. If necessary, we can conduct penetration tests. We also specialize in the areas of IT consulting, audit design, information infrastructure, including virtualization and cloud services, and of course business application and analytics, such as CRM systems, sales analytics, and so on. And we also exclusively distribute high-speed color cameras and specialized high-tech equipment for the video analytics and radio communication in Ukraine. And we also have competence in 7 directions of Microsoft Partner Program, including cloud platform and productivity, data centers, application development, collaboration, and small and medium business. So that's it for the introduction. Let's move forward to our topic. And as you know, as pandemic shifts organization globally to the remote work, there has been an increase of the use of video conferencing and team collaboration tools such as Zoom, Skype, Microsoft Teams, and WebEx, and so on. And when any technology sees its popularity increase quickly, the number of bad actors taking advantage of new and untrained users, of course, also grows. And the world is seeing this now with video conferencing services and applications such as Zoom being hijacked. Nova's Zoom bomb and this attack have surfaced, and multiple reports of conferences were disrupted by, pornographic images, hate images, threatening language, and so on and so on. And recently, security experts, they provided details on Zoom password problems and how the hackers were able to use specific methods to discover meeting IDs and passwords for Zoom meetings. And while hijacked meetings are, of course, disruptive and disturbing for participants, a more dangerous threat is that intruders who can lurk into the meetings without revealing their presence. And it's basically a nightmare for corporate security and individual privacy alike. And another thing is also thousands of private recordings of Zoom meetings have been discovered on the web. So Zoom actually told that its own servers hadn't been breached and the videos had likely been uploaded by the users to cloud storage services, but they were easily found through the search because they used the company's default naming. So what I want to say that the good news is that many video conferencing products today include security settings that can probably prevent such incidents. But the bad news is that it's often left to the users with no security training to configure the settings. So we had to help them. And I want to start with common threats to the security which any organization can face while using video conferencing software. And I think every business attendee should pay attention to them because they can perform as a starting point when choosing the suitable technology for the needs of secure communication. So the first security threat is called compromise key attack. This happens when the attacker uses encryption key, stalls it, and gains access to a secure transmission. And also he can, of course, decrypt the data that is being sent. Denial of service, I think everyone is familiar with it, when the attacker can set invalid data to applications and services running in the attack network, disrupt normal function, send large amounts of traffic, and of course hide the evidence of this. Eavesdropping can occur when attacker gains access to the data path in a network and has the ability to monitor and read our traffic, and especially if the traffic is in plain text, it will be much more easier. An example of this attack is attack performed by controlling a router on the data path. So it's quite dangerous. Identity or IP spoofing occurs when the attacker determines and uses an IP address of a network or another network component to use it and without being authorized to do so. And a successful attack allows the attacker to operate as a normal entity identified by the IP address. Man-in-the-middle attack is very simple. It occurs when an attacker reroutes communication between two users through his computer without the knowledge. It can happen if the attacker modifies directory service, for example, Active Directory, and adds his or her server as trusted, and maybe modifies even domain name system to get clients to connect. Replay attack occurs when a valid media transmission between two parties is intercepted and retransmitted for malicious purposes. And last but not the least, spam and viruses. Spam is the same as spam, but for instant messages. It, of course, doesn't itself compromise the network, but it's quite annoying. It can reduce resource availability and production, and can possibly lead to a compromise to the whole network. So, based on this information about possible security risks which can occur while communicating, I described a couple of well-known solutions. Process needs, how to tune them to get the comprehensive security.
Sorry, Anna, please check your microphone and your devices because we have some noise on the line. So please inform us if you have any technical difficulties. Thank you.
I think some of the participants didn't mute his microphone, so we have noise. I kindly ask to, or now it's okay, I guess now.
Yeah, now it's okay. Thank you.
Mm-hmm.
Proceed.
So the first tool is Microsoft Teams, basically what we are using now. It's a hub for teamwork, a chat-based workspace. Now I tell you about 4 core promises that Microsoft Teams offers to create digital workspace. First, of course, is communication. So since preview, Microsoft Teams evolved to include a complete meeting experience, chat, voice, video, one-to-one or group in channels, sharing information in a transparent way. And when it comes to collaboration, Teams offers deep Microsoft Office integration. It enables today's workforce to use Office apps they're familiar with, for example, Word, Excel, SharePoint, PowerPoint, and so on and so on. It can help you to get somebody's feedback without sending it via email and storing locally a lot of versions of the same document. Teams brings all the Office services together. Of course, many business use other services than Office. You can customize Teams with tabs, connectors, and boards that include apps. Third-party apps. Microsoft has integrations with over 150 partners, technology partners. And for the developer community, Microsoft have also created an extensible platform to enable building apps and to integrate it with business processes. And when it comes to working with confidence, Teams comes with enterprise-grade security and compliance, manageability. I will tell you about this a little bit later. And now just a few statistical information. So since the pandemic has started, the work habits, of course, around the world have changed too, and the number of daily Teams users has increased rapidly, up to 44 million, and continues to grow now. And of course, the video conferences have started to happen much more often, making Teams one of the most demanding service for corporate remote work. So why it's so popular? Because it uses and helps you not only prepare digital meetings quickly, but also create accurate follow-ups to stay on top of the project. And in addition to this, there is a possibility for all participants to present his ideas and milestones of the project using a whiteboard, making sharing experience immediate. And another benefit is that Microsoft Teams is available through the 2 options. First one is cloud corporate subscription, and the second one is free edition available by simple registration for the daily routine. This allows you not only have video calls, but also free 10 gigabytes of file storage for the entire team, plus personal storage, and of course integration with all Office apps. And second great privilege of Teams is that to join the meeting there are several options on mobile, on desktop app, or just using a web browser with a single click, and it reduces time usually needed for the user to install software and launch meetings technically correctly. And as I said, using Teams enables tracking progresses and updates instantaneously with integrated apps, and also record meetings with transcript and save them locally to the cloud. And this opportunity is supported by Stream app. It's available also through the subscription, and using this tool helps you to share recording securely, but also quickly edit it and customize it, and vice versa. When you need to be certain about the integrity of the recorded file, Team can also help to ensure this from the technical side. About working with confidence, I want to say that Teams is compliant with many industrial and information security standards, and I think my colleagues from the second block will be more familiar with them, but I say that Microsoft Teams is compliant with GDPR, ISO standards, SOC 1, SOC 2, health information protection standards, and so on. So how Microsoft Teams can help defeat security threats, which I mentioned before. For the compromise key attack, Teams uses public key infrastructure features that protect the key data used for encryption for the TLS connections. So all the media encryptions are exchanged over TLS connection. When it comes to denial of service, these attacks are mitigated by running Azure DDoS network protection and by throttling clients' requests from the same point, subnets, and maybe entities. To help to protect from eavesdropping, Teams uses the protocol which is called mutual TLS or MTLS for server communication, making it very difficult to impossible to achieve this within the time period in which a given conversation could be attacked. And TLS authenticates and encrypts all the traffic. This doesn't actually prevent from eavesdropping, but the attacker cannot read the traffic unless the encryption is broken. So identity spoofing, same. TLS authentication to protect you from man-in-the-middle attack. Teams uses SRTP protocol, secure real-time transport protocol, to encrypt the media stream. To replay attacks, again, SRTP in conjunction with secure signaling protocol that protects transmissions from replay attacks by enabling the receiver to maintain an index of already received RTP packets and compare each new packet with those already listed in the index. And for viruses, there is a special service called Advanced Threat Protection. It's available for Microsoft Teams. It allows you to determine if content in these applications and when exchanging in videos and messages is malicious in nature and blocks this content from user access. And how the affected content is managed after detection is up to the settings you've selected in your Office 365 subscription. So that's what else? And there is a summary of the protocols used by Teams for the encryption. I will not stop on them, but just for information. And another important point for not only for Teams, but for all video conferencing systems is client authentication. As you know, authentication is the provision of user credentials to a trusted server service. And when we talk about Teams, it uses the implementation of Open Authentication Protocol for client-to-server communication. And it also enables security features such as multi-factor authentications for everyone, PCs, mobiles, web clients, all support multi-factor authentication. Then, a lot of threats addressing medians can be connected to who arrive in your meeting, who have access to the information you present. So in Teams, you can have two options to control this. The first one is called lobby. It's basically what we use today, I guess. So people in your organization can bypass the lobby and, for example, anonymous users or users outside the tenant go through the lobby, and then someone should take them in the conversation. And the second way is through the structured meetings. Structured meetings are based on the role model, where presenter can do anything about the meeting, and the attendees have a controlling experience after joining the structured meetings. The action which presenter can control includes speaking, recording, sharing content, and so on. Of course, another important point when we talk about secure communication in daily routine or corporate governance are information barriers. In Teams, information barriers are policies that keep people or groups of people from communicating with one another when there is no business need to do them so, or for example, there is a regulatory reason to block them from doing so. So it also allows you to set policies relating to things like lookups and electronic discovery. When it comes to communication compliance, Microsoft Teams can examine communications for the offensive language, sensitive information, and information related to internal or regulatory standards. Also important thing is data loss prevention. I think everyone is familiar with it. In Microsoft Teams, whether you have concerns around sensitive information in messages or documents, DLP policies will be able to help ensure your users don't share the sensitive data with the wrong people. And maybe the most interesting for you is electronic discovery. This is electronic aspect of identifying and producing electronically stored information in response to the request for production in a lawsuit or maybe investigation. These capabilities include case management, preservation, search, analysis, and export of Teams data. So this includes chats, messaging, files, call summaries, and for Teams, these are created and made available in electronic discovery. And during the litigation, you will need all the data associated with the user to be preserved as immutable, so it can be used as an evidence for the case. And you can do this by placing either a user mailbox or a team on a legal hold. It is possible in Microsoft Teams. A few words about another tool, popular, everyone heard about it, is Cisco Webex. How can you tune it for better security? Of course, it also has encryption at runtime and end-to-end encryption itself, but another important feature of Cisco Webex is personal room. The personal room can be thought as personalized virtual room where host is available, and Cisco allows to log your meetings in personal rooms automatically after the meeting starts. And of course, this prevents unwanted people from joining your meetings. And the last is enforcing meeting passwords when joining from phone or video conferencing systems. So users joining your meetings use a telephone or video conferencing system. They will be required to enter numeric meeting password before being admitted into the meeting. And the numeric passwords will be provided in the meeting invitation. And this will be applied to all scheduled meetings. So I've described only two solutions, but of course there is a vast choice in this field. And no matter which technology you implement, from the user's point, it's everyone's responsibility. And you probably should follow the recommendation described on this slide. I will not comment them. They are very easy. They require login, not forgetting to lock your lobby, then setting passwords, exchanging it securely, and of course setting passwords for the recordings before sharing them, and not forgetting to delete these recordings after they are not needed anymore. And to sum up, my presentation has a checklist for choosing the technology solution for secure communication, including video conferencing. The first one is strong encryption. I said a lot about it today. The second one is reliable authentication plus multi-factor authentication. It's actually the single best thing you can do to improve security for employees. And if you don't have already processes in place, treat this as an emergency pilot. for example, and make sure you have support ready to help employees who get stuck. And as you probably can, distribute always hardware security tokens or devices. You can use Windows Hello biometrics, smartphone authentication apps. Please don't forget about it. The functionality of role-based access in waiting rooms is super important. Another important thing is application management. So you should be able to use app permission policies to block or make certain that certain apps are available to specific sets of users. DDoS protection, no comments, very important. And when it comes to working with sensitive information, pay attention to information protection tools that they must be built-in video conferencing system. For example, information labeling can help you to ensure that your DLP policy actions are applied correctly. Of course, audit features for users' activity for further investigation. Communication and industry compliance, depending on the industry you are working in. Legal hold features, if you want to use video conferencing system in courts and so on, there must be in place. From the technical side, it's important that the solution has per-organizer and per-user security policies. And a huge plus for the technology for secure communication is device management. If it is built in, it's super great, because mobile device management allows you to monitor that the devices which users use to launch the meeting are patched, up to date, don't have viruses, and so on and so on. And the last thing is important also, is it is trustworthy by design. It means that the app you're using for secure communication must be designed in compliance with some well-known development lifecycle. So it is actually the first step in creating a more secure unified communication system, because it helps to design threat models and test each feature as it was designed. And so multiple security-related improvements were built into the coding process and practices, and build-time tools can help to detect buffer overruns and other potential security threats before the code is checked into the final project. So please pay attention to this checklist when you choose the video conferencing solution, both for your daily usage or codes and so on. So that's all from me today. If you have any questions, I'm ready to answer. If you have specific technical questions or maybe about other directions that Silvery as an IT company covers, so feel free to contact us. You can see the information below. So thank you for your attention.
Thank you, Anya, for the technical introduction for point for us. So I suggest we start legal and technical aspects of telecom for daily business communications, and I would like to point that each country and each jurisdiction has its own tradition of use of telecom for business. For instance, in Ukraine, it takes just about 1 or 2 years before when the telecom and video conferences came into daily routine of the companies in Ukraine, basically for IT companies and for great teams, international teams. But nowadays, we'll have video conferences for each segment and each field of business: IT, transport, I don't know, some retail companies, etc. And I'll be grateful if your dear colleagues share your experience of use of video conferences in your businesses and in your jurisdictions, and other companies in your jurisdictions have a habit of use of video conferences, or just preferred some face-to-face meetings, not only before the quarantine regime, but after this lockdown. What is your point on this issue, and what do you predict on use of video conferences for business matters? Thank you. So I'll give a floor to Mr. Vasil Popstasiv just to share experience on Ukraine, and I'll be also grateful for our speakers from other jurisdictions also to share your points on this matter. Do you think that video conferences will be rather permanent habit for companies and business in jurisdictions? And do you have any legislative regulation of it, or maybe some companies take internal rules on use of video conferences in its corporations? Thanks.
Thank you, Tatiana, for your question. Is sound okay? Just checking the sound because I had some troubles connecting the.
Everything okay? Thanks. Vasily.
Everything is okay. Wonderful. Yeah. So Ukraine is not like some country where the technologies are not implemented. So in many cases, many companies do implement modern technologies, especially video conferencing for their daily routine, especially in IT companies, which collaborate with their overseas partners. And this is like a normal daily practice of discussing daily issues with their partners in the United States and in Europe, for example, in Austria and Germany as well. But if we are talking about the security issues in Ukraine, it is not something new because actually we have legislation that regulates the information security issues. Of course, this legislation was concentrated on telecommunication systems, such as telephone conversations to protect the telephone conversation, firstly through ordinary phone lines, and after the mobile phones were implemented and cell lines were established. So the mobile operators are also very keen and very attentive to the details about the security of their communication systems. And actually, when we start analyzing the security issues for our clients who are addressed with this issue, when they were asking about how do they need to protect their systems, is there any kind of regulation or whatever, actually found that this regulation in telecommunication sphere may also be applied to the ordinary business, to private businesses who conduct video conferencing and distant communication with their offices in other countries or with their employees or contractors, like in other cities. Those regulations may also apply to these communications as well. So in terms of experience, Ukrainian companies, especially Ukrainian IT companies, they do use these modern technologies. They improve their security issues because this will influence the ability of new clients to trust them and to come within new tasks. But when we speak about the established businesses, about large enterprises, which are concentrated more offline rather than online, and they didn't used to utilize any distant communications like Skype, like Zoom or whatever. They ask questions, maybe for IT companies pretty standard or maybe naive. How do they do that? Whether they do need some kind of privacy policy update or whatever. And the standard issues here is depending on what kind of information is exchanged through this means of distant communications. Because when we are talking about the distant communication, we are talking about the telecommunication sphere in general. So there is no much difference in legislation between the video conferencing using the internet and IP technologies between modern communications and the older communications such as mobile phones. So in case you have a policy which covers the communications in general, you could be covered. But if you forgot for some reason to include this point in your internal policies, that could be quite a problem, because from the confidentiality perspective, this makes your confidential information, this puts your confidential information at risk. And that's the major point, and that's the major thing the companies should address when they organize the daily routine, the daily routine of their employees and contractors, the daily communication. So in this situation, if you went from your normal offline communication to your online communication, you must spend a couple of hours. That's not a complicated issue. Spend a couple of hours analyzing what kind of information is accessible online, which wasn't accessible earlier online, of course, and what kind of means of protections are used. Because if you don't use any kind of protection for your confidential information, this could threaten the legal possibility to defend it, because any violation may not be declared or may not be recognized as violation at all, for the simple reason that the company didn't use any technical or organizational means for protection of this confidential information. But I believe that now we can move on, because we will talk about Ukraine more, comparing the experience of other countries.
Yeah, thank you, Vasil. And I would like to give the floor to our guests from other jurisdictions, just to give you a chance to share your experience. Whether do you have any particular rules on video conferences in your local legislation, or do the companies in your countries take any measures or internal rules to regulate this sphere? Because as far as I know, there are the severe data protection authorities, for instance, in your states, and I guess that I believe that the companies take care on this sphere. So please, Mr. Glass or Mr. Schulz, please can you share your point of view on this?
Yes, certainly. Thank you. So from the UK perspective, I mean, there isn't specific legislation which governs the use of video conferencing per se. It's caught more generally by data protection legislation and by sort of Companies Act legislation, which governs, companies and the obligations on directors to act in the best interests of the company, etc. On the use of video conferencing within the UK, it's been very sector driven so far. So, for example, commercial real estate businesses will probably be less likely to have used video conferencing historically than tech companies, for example. But it has been used reasonably widely for a number of years now, particularly when doing business with sort of US tech companies. And most businesses come at it from two perspectives, really, which is, to what extent does the use of video change security risk around personal data and data protection legislation, given the significant risks, significant potential fines for breaches of GDPR and data protection? And also, to what extent does it create the risk of third parties being able to access confidential information of the company? And that's either the company's confidential information is its own, or third parties' confidential information, which the company holds, which it holds under strict duties of confidentiality under contract, for example. And so what most companies have been doing when they shifted to video conferencing, if they do it well, is, as Vasil said, reviewing internal governance, internal policies, making sure that those are fit for purpose in terms of information security, acceptable use, etc. Looking at that when you currently have a highly distributed IT network with all employees working from home, or a lot of employees working from home in the current situation, and making sort of process and organizational changes as necessary on that. But also from the information security perspective, what was being discussed by Anna at the start, that kind of review of, okay, what platforms are available, and effectively undertaking a sort of software as a service security review with potential vendors when looking at what the systems are, looking at, how well do they integrate with existing systems? To what extent are they encrypted? To what extent are they secure by default? And what changes does the business need where it's not where it's not secure by default, to actually ensure that the rollout and integration of video conferencing systems are properly secure, and also pushing out proper processes to staff so that they understand how to use it, how to invite people to conferences, how to actually operate the technology well, so they're not decreasing security, which is put in place by the business as a matter of practice. That's just sort of a very quick overview. In the interest of time, I'll hand over to Andreas for any additional points that he has.
Thank you. And as far as I know, ICO took additional measures, related to quarantine regime, just to give its advices on video conferences, and there's data protection issues during the video conferences. Am I right?
Yes. Most businesses have had to look at. With staff working from home, what additional security risks does that create? And most businesses have updated policies, pushed out training to employees to make sure that they understand the do's and don'ts, so they're not creating additional security risk. Yes, and to be honest, I think that will continue post. After COVID, when people go back to sort of working in the office, because I think there will be more ongoing shift to people from working from home more commonly.
Okay, thanks. And despite the Ukrainian Data Protection Authority, which gave nothing on the matter of security here in Ukraine related to COVID-19 and use of some technical communications. Okay, thank. And I would like to give the floor to Mr. Paul Voigt and to Mr. Andreas Schulz, just to share your experience on dealing with teleconferencing and whether these matters are regulated in your jurisdictions, because as far as I know, Germany and Austria companies take a great number of care on the matter of security issues, and each company has its own internal rules on use of some providers and some kind of technical communications, and anyone is authorized to use anything except for this list of programs or do anything which is prohibited. So please share your experience on Austria and Germany. Thanks.
Yeah, maybe I can follow up on Paul's thoughts from a German perspective. So at least for Germany, similar to the UK, we do not have specific legal rules for using video conference systems, but it's a general privacy law that applies. And this certainly creates concerns with the data protection regulators that have issued quite a lot of guidance, in particular in relation to the COVID crisis. Yeah, because as has mentioned before, so many companies have switched to video conference systems rather than phone calls. And the issue is that if you use a regular landline phone call system to communicate, these respective phone calls will be subject to a separate regime of telecommunication regulations requiring a certain degree of secrecy of communication. So the communication provider cannot just access the respective data and only use such data to a very limited amount of purposes, and if the telecommunication provider does not comply with these rules, this can be considered a criminal offense under German law. So when using video conference systems, these telecommunication rules very generally do not apply, meaning that you cannot rely on these third-party video conference providers to comply with respective secrecy obligations. So if you do use respective video conference systems, you will have to comply with general GDPR obligations, basically choosing providers that are considered competent and provide adequate protection of the respective communication. You have to make sure that the technical and organizational security measures are in place, and you obviously have to conclude data processing agreement with these vendors, and if they are based outside the European Union, potentially implement additional safeguards to ensure that if data is transferred abroad, everything is still in line with data protection requirements. But this is obviously just one part of the obligations. If you use a respective provider yourself, you can choose whether this is someone who provides appropriate protection or not. And actually, by the way, for example, the Berlin authority has provided some guidance on that, and they, without giving further information, they have considered Zoom, which has been quite a lot in the press recently, but also actually Microsoft, which we are using right now, as non-compliant with the respective privacy regulations. But assuming you have one standard provider that you're using, you can oblige this vendor to privacy agreements, and you can carefully choose this vendor. But obviously, if you communicate with third parties, you often have to rely on their video conference systems, where you do not have any control in that regard. And here it often makes sense to give some guidance to your employees on how to deal with these video conference systems. What are you allowed to do? Which information are you allowed to share? For example, if you have to rely on a third-party system that you have not chosen yourself, potentially do not share information that could be regarded as business critical or sensitive, and actually giving some guidance to the employees in general on how to deal with these kind of systems, not only video conference systems, but actually working from home in general. We see it quite a lot of the present presenters today. They're working from home. You can see the home, the pictures. Here I'm in the office, you can see the whiteboard behind me. Obviously, if you don't take care in that regard, potentially if I would have confidential information on that whiteboard, this would be spread across all participants of this video conference. So you do have to give some guidance to employees on how to deal with respective confidential information. Actually, I've seen Boris Johnson, for example. Sorry, Paul. He has a perfect example of how he shouldn't do it. He was working from home before he was not working at all for a certain period of time, and he bragged a bit about that his cabinet all are working from home and they're using a Skype conference or a Zoom conference, and he basically posted a picture of the Zoom conference showing the usernames of his entire staff of cabinet and to the whole world, also showing the Zoom meeting room ID, potentially allowing third parties to bomb the respective Zoom meeting. Yeah, so you see quite a lot of people are not really aware of the issues that can arise when using these systems, and you very easily have some kind of leakage, some kind of potential data breach. And if you have that, either because the system you're using is not secure or because you involuntarily shared information on such system, this might even lead to notification obligations to the privacy regulators. Yeah, Andreas, I don't know how is the situation in Austria?
Maybe I can add something from the French perspective, because our authority, so the CNIL, which is the French Data Protection Authority, just issued specific guidance for the use of the video conference applications. So it's totally new, and it's really helpful in order to select the new applications, and in order to see how what are the good practices in order to use it. So and of course in our context of the COVID crisis, it helps numerous people which are using those kind of application. So in a business context, it is now highly recommended to provide equivalent guidance, for instance, in a dedicated internal policy to employees who are likely to use such applications in their day-to-day business, especially during the time of the COVID crisis. As you will see, the CNIL guidance is really a set of basics, good practices to avoid abusive and unsecured use of video conference tools. The guidance is split in 3 pieces, so in 3 parts. The first one, which is good practices before downloading the apps, so how to select it. Then good practices when creating your account. And finally, good practices when using the application. So it's really, really pragmatic. So before downloading the application, the recommendations are first select solutions, of course, that protect privacy, such as applications certified by a specific national agency. For instance, we have the application TICSEO, which is certified by the French National Cybersecurity Agency, the ANSSI, which is highly recommended by the CNIL. You need also to avoid downloading the application from an unknown website or source. You need to only use applications for which the editor clearly tells you how your data are reused, of course. So in the application itself or on the website of the editor. For example, you need to read user comments in discussions forums or from your phone in application stores. Check that the publisher has essential security measures in place, such as encryption of end-to-end communications. Secure your Wi-Fi network, because that's also one main point, with a strong password by enabling WPA2 or WPA3 encryption, and make sure your antivirus and firewall are up to date. That's for the selection before you download the application. Then when you create your account, whenever possible, it's better if you really limit the amount of information provided during the registration process. Use a pseudonym and a dedicated email address. Check the privacy options provided when creating the account, etc. It's highly recommended to use a password that is different from those used on other online services, because that's really a key point for the security. Read the general terms of use, of course, and in particular, the privacy policy section. And finally, when using the application, the recommendations are to take the time to look at the application settings, particularly with regard to protecting your privacy. For example, check whether there are options that allow you to download your data or limit the use of certain information. On your computer or phone, close the application when you are no longer using it, especially if the microphone or webcam is activated, and turn off your microphone and webcam when you are not using them. So you can also physically hide your webcam, for example, with a piece of tape or so a really practical, simple, and basic set of recommendations that is important to make your employees aware of, in order to avoid potentially important security issues. So that the guidance was issued 3 weeks ago, and it's now part of our good practice here in France.
Many thanks, Valerie. And to take the truth, here in Ukraine, we also use the practice of CNIL just to understand some issues related to privacy of employees. And in this case, we also use the recommendations of the French Data Protection Authority to develop and to draft some regulations for employees, for Ukrainian companies, just to use properly with their technologies, and in this case too. Okay, thank you. So I would like to give the floor to Mr. Otto Slikin, partner of Telewrestling from the Netherlands, and to ask of your experience in regulating video conferencing, because as far as I know, there are a lot of companies from all over the world with which have their headquarters for EU and EMEA states in the Netherlands. That's why the Data Protection Authority of the Netherlands is very active too. And what is your point and your predictions on use of video conferencing for business matters? Otto?
Thank you, Tatjana.
Thanks.
Indeed, there are quite a few head offices located in the Netherlands in general and Amsterdam in particular. Actually, our next door neighbor is probably well known in the Ukraine. That's the head office for global operations of VEON, I think the second largest telco in the world. And they're actually next door. They're a clear example of lots of head offices that are primarily run by expats and only a few locals, but they do have their main bases in the Netherlands. I think after listening to Valerie explain on the CNIL and also hearing that that's actually used in the Ukraine, I have to say I'm a little bit jealous with that particular guidance, because in all honesty, I do not believe that the Dutch authority is on par when it comes to really give proactive advice and steering towards the current situation. So what we've seen over the last 7 and 8 weeks is that parties have been forced to send their workforce home to a maximum extent. In order to do so, lots of organizations were not fully prepared on doing this for the complete set of operations. So even in law firms, for instance, most lawyers are used to working from home for, well, maybe a couple of days a week as a maximum. But supporting staff and secretaries, of course, are not. And to also give them proper access has been somewhat of an issue for some companies. Because it all starts with, of course, having the ability to work in the cloud with your complete environment, and most organizations nowadays offer that kind of setup. But then it creates issues when you want to approach the cloud environment from your home Wi-Fi network that usually is not as well protected as it should. So if you, for instance, have two-factor authentication, you're usually well protected. The only issue there is that not in all organizations do all the employees have company phones. And certainly most do not have separate tokens for using two-factor. So all of a sudden, lots of companies had to either implement a quick way of setting up the two-factor for a large part of their organization, or switching to basically limit security. So examples we have seen was to move away from the two-factor in total. So just setting up a one layer of authentication for the complete cloud environment, which of course is very tricky, especially when people connect up using their home Wi-Fi setup. Because in some cases, of course, there are other machines in the network, such as smart TVs, etc., that have not been updated. Sometimes the Wi-Fi routers, of course, are still on the standard setting. So it's relatively easy to penetrate the network, which also means by lifting the two-factor, it's relatively easy to gain access to the cloud environment. Another method that we have asked questions or received questions on is whitelisting the IP addresses. So basically collecting all the IP addresses for those employees without the option to use two-factor. Which of course is in my view slightly better than lifting the two-factor altogether, but it still runs a risk of, for instance, IP address spoofing. So all those issues are definitely a factor in the current status of cybersecurity. And I would have liked our local authority, the AP, to take a proactive stance, but they've appear to be quite conservative. It took them weeks to come up with a first guidance on whether or not employers are allowed to ask questions relating to Corona to their employees. And up until this moment, there has not been given any additional information on, for instance, the use of video conferencing, the status of the IT providers that offer solutions. So, for instance, when the security issues with Zoom prior to the 5.0 version were released into the public forum, there was not a single statement of the AP saying that parties should steer away of Zoom. So they've been, very reluctant to take an active stance. And I think on one end, it would be good to apply the CNIL method, so actively focus on user awareness, because I believe that lots of people have a tendency to basically just use whatever is at hand. So whether it be social media or another free software tool such as WeTransfer, Dropbox, etc., nobody ever takes care of reading the terms and conditions. Nobody hardly checks the privacy settings and so forth. So there they should really take a more proactive stance and advise the users, the end users, on the risks and just have a couple of checks and balances built in before using those kind of applications. And on the other end, there's probably a responsibility towards the organizations that offer these kind of solutions. And to take, a more, I would say, professional check at the start of using these tools, because I believe that, say, 8 weeks ago, probably most international businesses and the larger law firms, for instance, consultancy firms, they were all using Microsoft Teams already. But all the various options, BlueJeans, Zoom, Google Hangouts, etc., they've rapidly gained exposure over the last 8 weeks, and now all of a sudden every organization is rushing to implementing those, probably without taking enough time to sensibly assess the security impact it has on their organization.
Thank you, Otto, for your position on the use of telecom services and telecom devices for operational business in your jurisdiction, and especially from the point of view of such international corporations of telco like VEON, etc., because in Ukraine we also have a great VEON division named Kyivstar. Yeah, that's why they are very active in legislative initiatives, etc., just to share their experience from international point of view of use of video conferences for operation of business in their corporation and in Ukraine too. And I'd like to give finally a floor to Mr. Andreas Schulz, a partner of Teleresin from Austria, just to describe the situations there and maybe emphasize of some amendments in Austrian legislation because of the pandemic and the further use of video conferencing for the companies there. Andreas?
Yeah, hello. So welcome from Vienna. First, I have to say that I think normality is slowly returning because I'm sitting in the office and we're in the lucky position that we can reboot our office next week. So we're hoping that times are going better. For the first thing, thank you to complete the picture what Paul from Germany also said for according to the German jurisdiction. And in order to avoid repetition, not only because we are often seen as the smaller brother of our German neighbors, but we have the same legal framework or similar legal framework. In Austria, we have also not, like Valerie told us, a real good guideline. We have only from our data protection authority kind of general guidelines for home office, but not for video conferences at all. And so this is the point that from the company itself, they often have their own rules, like also the good example of Boris Johnson. We also for our lawyers, we told them not to make any pictures during their video calls. Often it's quite interesting and funny to have 20 different participants, but this is rather from also a data protection perspective, not the best way to really spread it. I made a picture yesterday, but it was officially announced. And this is also an example in Austria for new developments. And I will share the slide to you, so you can see what is brand new in Austria for virtual AGMs. So I think this is something what is in the most jurisdictions now common. But I was in a lucky situation that I could share because it was starting at this week at even now 3 of this new kind of modern way for AGMs. So for sure, due to recent developments, including the ban of meetings and travel restrictions, it was practically not possible for stock corporations to hold a general meeting in the, let's say, traditional manner in the current situation. So, however, even in times of coronavirus, the shareholders' right to physically participate in the general meeting cannot be waived. So since the latest Corona Act in Austria, and in order to prevent the spreading of COVID meetings of shareholders and board members of corporation and other forms of companies can be held without the physical presence of the participants, and resolutions can also be passed in other ways. So it was at beginning or middle of April, the Minister of Justice in Austria announced a special audience on the more detailed regulation of holding such meetings and a company without the physical presence. And the general meeting of stock corporation does not necessarily have to be held via an acoustic and optical two-way connection. It's so more a hybrid way. So instead of, it is sufficient for individual shareholders to be able to watch and listen the proceedings for the meeting in real time by means of an acoustic and optical connection. It doesn't hurt if any half of the participants listened to the meeting at all. So, but however, the individual shareholder must be able to make requests to speak and participate in votes by other means during the meeting. So under certain conditions, it may be provided that the filing of the shareholders' resolutions, the casting of votes, and the raising of an objection in the virtual meeting can only be carried out by special proxies appointed by the company in certain circumstances. And this was our rule. We were here this kind of appointed proxies. To this end, organizational agreements must be made so that the shareholders can still change the instructions to the proxies in a very fast way during the meeting up to a certain point of time. This may also require, for sure, a brief interruption of the virtual meeting, but it must also be possible for the shareholders right to information to exercise by the shareholders themselves in this type of implementation. Whether the question during annual general meetings are sent by the shareholders directly to the company or to the special proxy. And there you can recognize there are a lot of very sensitive topics from data security and data protection. And in practice, these services are provided not by the companies itself for sure, but more by technical providers. This is where the greatest demands are placed on data security. For example, the data of all shareholders is stored in the system. So from every single shareholder who is registered before the meeting, and in order to be able to check whether each shareholder is actually entitled to participate virtually in the meeting and to exercise his or her voting rights. And so the individual proxies receive proxies from the respective shareholders, which are managed by these technical service providers. And the proxies only receive, and let's say only the proxies receive a complete list of all shareholders registered for the AGM. But this is only shortly before the start of the meeting via the separate intranet system to prevent any external access. So this was during the very long meetings. One interesting thing to go through all the lists, and so we have been allowed to do that. But there you can see also the awareness from data protection side. So at this point, special caution must also be exercised from the data protection perspective, and for security reasons. The biggest problem here is not malicious access from outside, but more technical aspects. So the most significant problem, we also recognize that since problems can always arise when using electronic means of communication, legislator makes it clear that the company itself is basically only responsible for its own technical fear. So therefore, if technical problems occur during the transmission of the general meeting, claims for damages and the contestation of resolutions can in principle be assessed if the problems of participants in the virtual meeting is the more likely it is so let's say when you have a very small group of participants, then you have to interrupt the virtual meeting more quickly in order to enable to re-establish the connection. So the circumstances around COVID-19 were driving force to establish, let's say, already existing systems because they tried it before, but as quickly as possible and to make them suitable for practical use. And at this point, it is interesting to note that such models have been under consideration for some time, but only on this occasion they now have been implemented very quickly in law and in practice for sure, and suppliers have also found solution extremely quickly to ensure this technical implementation. And so at the second meeting, I recognized, or we recognized there, that it was, and it was a really huge stock company in Austria, was suddenly interrupted because it was discovered that there were some problems with the streaming. And in this case, it suddenly had to be decided where the cause was. So if the stream was correctly sent or broadcasted, And then the problem was with the individual participants, or if the signal was not properly broadcasted by the shareholders meeting. So in this specific case, it was a major breakdown of the network operator throughout whole Austria. And so it was not in the sphere, and there was even the notary public who is joining the meeting, and they were discussing, shall we repeat the whole general meeting? Shall we repeat only the points where we recognize that the broadcasting was interrupted? And even they made some decisions paying out dividend to the shareholders. And so today they are still not sure what I recognized, whether they can do it, because some of the participants, they say we won't accept it and we will complain because we weren't able to follow the whole streaming. But in this case, so it could be argued that it was not in the sphere of the company. So this is, you can see also a very practical thing where data security and technical security is kind of important thing, and and you have to act very quickly during this whole streaming what you can do. And so if the security has established itself, it's certainly a real alternative for the future, I think. And so also, in any case, I think it's interesting to see whether in future some of these systems will also prevail in the time after COVID, and I hope this will coming soon to us. And yeah, I only can say what is the negative flip side of that. In real AGMs, it lives from the course from the certain moment, and I think this is not possible in kind of these virtual things. And also there is no Buffett, but maybe you can compensate this with delivery service in future. So I think this is a good example for development in the last weeks in Austria. Thank you.
Yeah, thank you, many thanks, Andreas, for sharing your experience. Not only our, yeah.
If you allow, I have a question as a matter of our discussion.
Yeah, sure.
The question is also to Anna. The regulation of Ukraine claims that actually the law of Ukraine on protection of information and telecommunication systems states that the responsibility for protection of information bears the owner of the system, and under the system it means the telecommunication and information system. So the question is it possible to claim any losses against the provider of the service? I mean, the service for security of the security services. So in case of the company which provides the service that establishes the software and provides the hardware for different tasks, is it possible to claim the losses against this service provider as a contractor if you are not owning the system, if you are not the company who actually buys the hardware, who actually buys the software, installs and manages it?
Okay, I understand your questions. No, there is a possibility of so-called shared responsibility when half of the responsibility is on the owner of the system and another half is on the service provider. But it must be regulated by adding additional contracts between them, so then can establish and divide their responsibilities specifically.
Thank you, Anna. Andreas, did you experience anything in Austria due to recent leakage or breakage?
What do you mean from the legal side, or what are the roles from your first question? Whether you could sue your provider or?
Yes, if you ordered security services from a third-party provider, for example, you addressed to the company who is specialized in providing of security services, can you hold this company liable for any security breach in your system? Can you address this issue before the court or protect your managers in terms of corporate governance, that the managers did everything possible to protect the system and the information, the valuable information of company? However, the security provider, which supposed to provide the security for this for the company, actually failed. Is it possible under Austrian legislation to do?
I think that's the point. In your last sentence when you said they failed. So for sure, it depends what is in the agreement with your provider. For example, when there is a kind of I don't know, unforeseen force majeure, whatever, like we had 2 weeks ago, and the whole network breakdown in Austria because it was too much traffic at the same time, or you don't have the real security measures, then for sure there is no possibility, because you in Austria, it's important, I think, like in all other jurisdictions, that your contracting partner has to make a kind of mistake, and that's the point when you can sue him.
Thanks, Andreas. I would like to suggest turning to the specific topics related to video conferencing and to speak about the measures of use of telecom technologies for court representation and in arbitration institution. And in this regard, I would like to give the floor to Darina Hrebenyuk, who is Associate of Alternative Dispute Resolution Practice in Artsenger, Ukraine. So, Darina, I'd like to ask you whether there are any amendments and changes in Ukrainian legislation related to pandemic, and are there any consequences for further representations of the companies before the courts remotely? And whether do you know any positive practice from different arbitration institutions? Thank you.
Good morning, colleagues. Thank you, Tatiana, for this introduction. Thank you, colleagues, for having me today. I really enjoyed the discussion up till now, and hopefully I will contribute efficiently to this discussion. So I will try to be very brief due to the brief time limits that we have left for our session. I will divide my presentation into 2 parts. First one, the courts, and second one, arbitration. So in terms of courts, many think that once the COVID crisis and quarantine came to be, Ukrainian court system was totally unprepared in terms of video conferencing and electronic court hearings. This is not quite true, and I will give you a few figures for that. So the first video conferencing resolutions were implemented into the law in 2012. so it was kind of 8 years ago. The idea was that if your company is located in Kiev, and naturally your in-house lawyers are located in Kiev, and you have, or your external lawyers, and you have a court hearing somewhere in the Western Ukraine, for instance, and you cannot travel there for whatever reasons, you can participate in this court hearing from Kiev. To this end, you had to file an application, and the participation was, you could participate only through some other court here in Kiev. The idea behind participation in another court was that the representatives of the court could check your authorities, as simple as that. And this system worked for some time. The problem was that most of the courts do not have the necessary hardware to ensure this participation. But this situation changed gradually over the time. The next developments came to be with the judicial reform in 2017, whereby now you can participate, or your in-house lawyers can participate in the court hearing wherever you want to be, from your office, from your home, whatever. The only requirement is that you have to participate through a specific platform, and to enter this platform, you have to provide the electronic key. So this platform will authenticate you, will check your authorities through your electronic key. Now, the issues with that was, first of all, this program was still underdeveloped, and the second is the problem with electronic keys. Many people, less so among the attorneys, more so among the company's representatives, do not have the electronic keys. So you cannot efficiently participate through this system in the court hearing. But this most importantly is that starting from the 2017, Ukraine started preparing this platform and started launching these electronic key systems. Now, what changed now during the quarantine? First of all, at the time of the quarantine, so to say, implementation, Ukrainian authorities already had the platform that allows you to enter with the electronic key and participate in the court hearing. You might have heard of this platform. It is the EasyCon. So why EasyCon? Why not WebEx or Cisco or I don't know, Zoom or whatever? Like I said, this is the only platform right now here in Ukraine that allows authentication through electronic key. No other platform allows for that. Now, this doesn't mean that all the courts strictly adhere to this system. Even before the reform in 2017, and even before this quarantine crisis right now that we're having, the courts adopted decisions to hold court hearings through Skype, through Zoom, through WebEx, and whatever. How that worked? Well, quite interestingly, you could authorize yourself through showing your documents to the camera. And the courts, some courts were okay with that. So as to the practice, how this works, it depends majorly on the court and depends majorly on the judge and his ideas of how to hold these hearings. What in terms of law, after the quarantine is ended, we're back to the basics. We're back to the system where you can participate in the court hearing solely through the electronic key and through the EasyCon system. In terms of practice, I believe, and the legal community believes that, once again, depending on the judge, there will be possibilities to participate through Skype, through Zoom, through whatever system that the court is able to ensure that it will be working and that it will be providing the efficient proceedings. In terms of security within these proceedings, the community doesn't believe that it is such a trouble right now, because even if, for instance, we know that Zoom is not that protected as a system, even if some third party is able to enter into this meeting and hear and see what is going on inside, well, under the law, the court hearings are open in any case. So in real life, you can enter the court and you can go to any hearing you want. So the judges do not see such a problem in that. What is going on now? What is our court administration doing right now? They are understanding all the issues and all the problems that might arise in the future. They are working with the, I think now they're working with the two platforms. This is WebEx and this is Google Teams. They are discussing whether they are able to provide the necessary technical resolution to ensure some alternative to EasyCon, because under the law there is no such strict requirement that this must be only EasyCon and nothing else. One small comment: why EasyCon? Well, the system was developed by a state-owned company, and basically it was in the ownership of the state at the time of the quarantine. So this was the easiest way to proceed. So this is why they basically moved with that. Now, moving to arbitration, it is important to note that this issue of teleconferencing, video conferencing, was never quite an issue in the recent times with the arbitration, because the court hearings, the case management calls and whatever have been held in arbitration for years now, very efficiently, very effectively, and with all the possible means, whichever is more comfortable for the parties and for the arbitrator. There are many specific platforms that work specifically for court hearings and for arbitral hearings, developed for the arbitration, developed for the judicial system. Some of the most prominent ones. The first one is developed and promoted by the ICDR. This is American Arbitral Institution, called Opus 2. And one more that I will mention is eMediation. I think Vienna is fond of this platform, as far as I'm concerned. So those platforms are very comfortable in terms of how they were developed. They were developed specifically for the court proceedings, for the arbitral proceedings. So you have those separate rooms where you can remove some parties. As an arbitrator, you can remove some parties and hold the negotiation between the arbitrators only, or you can put expert witnesses or fact witnesses into separate rooms so that they cannot negotiate among one another, and so on and so forth. So those platforms are like super developed for these court reasons only. What is more important about those platforms is that there is a so to say, role of case manager. This is kind of a court assistant or arbitrator's assistant that is responsible for technology working properly. He or she ensures that all the parties hearing everything correctly. He or she is responsible for the record of the hearing, and so on and so forth. So these platforms are very specific. What is the negative side? They are quite expensive, and not all the arbitral institution or courts, for that matter, have enough funds to finance those platforms. So arbitrations are successfully held through Zoom, through WebEx, and so on and so forth. There is no such problem with checking the authorities in arbitration, because this is more of a negotiation and consent based type of adjudication. But what is the negative side of that? If you want to have a hearing online, you have to have all the parties consenting to it. And this is quite an issue that all the arbitral institutions are facing right now. If a party strongly opposes to a court hearing being held online, it is most likely that the arbitrators will postpone the hearing until later times. I don't know, maybe November, maybe the next year even, and held this hearing in person, which is not this problem does not exist in court so far. So if the court wants the parties to participate online, he issues a resolution, and that's pretty it. One of the interesting cases that happened recently, I think this was 2 days ago in the US. This is the case of Cantor Patel, against Cisco, where this is a patent dispute, whereby the court, the Virginian District Court, first of all ordered that the hearings be held online, because the issue has been considered by the court since, I think, 2015. So this is quite a long time. You cannot postpone it further. And the second of all, despite that Cisco is a party, and the Cisco representatives insisted that the hearing was held by their platform WebEx, the court refused, and the court ordered the parties to participate through Zoom. And this is a, so to say, cool virtue of the court hearings, whereby the decision of the court is mandatory upon the parties, and it does not depend that much on the will of the parties. So they will be definitely heard, their arguments will be considered, but if the court decides to dismiss those arguments, the final judgment, the final decision of the court, will be mandatory for the parties. I think this is all from my side, and I look forward to colleagues from other jurisdictions sharing their experience on the same matters.
Thank you, Darina. So, dear colleagues, do you have maybe your views on the matter of courts and arbitration and use of video conference there? Does anything change, or everything is okay, and some remote representation of the clients before the court in the jurisdiction previously, and you didn't have any news on this? Thanks.
Well, I'd like to mention something for the Dutch perspective. I think probably for most countries, there has been a lack of preparation from the courts for a situation like this. Actually, in the Netherlands, it's probably even worse, because over the last 2.5 years, our government has been working on a project where the court proceedings would be modernized and would start to use an online platform for submitting proceedings. The project Kei, and last year it actually spectacularly failed. So it ended up as a 200 million failed IT project. Unfortunately, not the only one in the Netherlands. Basically, after that, they've been trying to figure out how to respond and to move away from the current system, which is very old-fashioned and actually still relies on fax machines to submit documents to the court. And email is still the official exception. So when they rolled into this situation, the first response was, we will postpone. The couple of court procedures we've started up over the last 8 weeks, we have been able to submit those. But the response is either we will postpone the decision on a court hearing until May or until further notice. And later on, they started to hand out dates for court hearings that are scheduled for last half of May and mostly June and July. So they try to push it into the future and see if there will be a solution on the horizon. The official statement on the website is also referring to the possibility of using video conferencing. Although for Taylor Wissing in the Netherlands, not one of my colleagues has actively received a request to do so. So we get the impression that it's more of a formal statement than it is actually something that they are using in practice. And the only exceptions to the rule of no court hearings are criminal cases and cases in family law. And neither of those are done by Taylor Wissing, so we have no experience in those two and whether or not those exceptions are actually met and in what practical means they are met. Probably for arbitration, it's a little bit different because arbitration tends to be more international in the Netherlands. But still, for instance, one of the institutes is the Netherlands Arbitration Institute. They also decided to postpone most hearings to further notice, although they do offer the option for both parties if they agree that there is need for more speed in the proceedings to apply video conferencing. And one of the other arbitration institutes, the Permanent Court of Arbitration, according to their website, there's not a single update on the COVID-19 impact. But as we discussed this earlier this week, I tried calling them, and so far I haven't been able to. So I get the distinct impression that even though the website does not report anything out of the ordinary, also for them it's probably a different model that they are using now, and they probably are taking in cases, but they are postponing the court dates until later next month or even beyond that.
Thank you, Otto. Thanks. And here I see that our colleagues from Ukrainian business, from Siemens, Konstantina Avranidi and Kristina Kostyanova from Rodina, have also participated in our discussion. And I would like to ask you whether companies have any changes and amendments related to teleconferencing because of the remote work, and is maybe it's a usual habit of companies to use telecoms for your internal meetings or some corporate events, etc. So I'll be really grateful for your experience and for your speech now. So, Konstantin, Kristina.
Yes, thank you. Well, first of all, thank you very much for a productive discussion. I've been following all the speeches, and it's been useful for us. I'm not a lawyer. I'm a business development manager in Rodina. We construct solar power plants, just very briefly. And of course, this time of COVID restrictions has been very challenging in terms of communication, in terms of remote, distant calls. It's not easy, definitely. First of all, the challenges are in, I would say, level of IT education of all the employees. It's not easy to connect. It's not easy to install on time, and it created some difficulties. But my question would be, and my main difficulty right now is how to control participation of large group of participants in distant calls. So whenever you arrange a call, and then if there is no video option, you speak, you guide some meeting, but you're not sure what people are doing now. So they may be typing some emails, they may be talking to someone else. And definitely the main tool is a self-confidence that you are participating in this meeting, but it would be also for me to know some practical tools, how maybe colleagues, how they guide these issues. What do they do in order to make sure that their colleagues are with them right now during video distant calls? Yes, I don't know if you understand my message, my question.
So, dear colleagues, maybe some insights from your practice and from your side. Please share it with us.
You mean as for us?
As for me, there may be different types of controls. The first one is a matter of agenda, that each one should have a clear understanding on what topic will be discussed, yes, one by one. The second point I would like to consider is that there should be any kind of authentication of the participants of the meeting, meaning that each one should take some login and payroll just to certify that he is participated himself, yeah. And the third one is making some resulting parts, some resumes of the discussion, yeah, to have each point controlled and to have some solution and settlement for each point of discussion. that's all that I can suggest from my experience of constant conference calls and video calls during these 2 months. So, dear colleagues from other jurisdictions, do you have any tips on how to be effective during the video calls and how to work with your colleagues just to gain some results during such sessions?
Thank you, Tatiana. I would like to add something. Unfortunately, my computer is lagging with video, so I turned the video off. Christina, maybe you will be interested more in the next week webinar. We'll be talking and discussing about the employment issues on 6th of May. So we will be covering especially the control of the effectiveness of the employees and how to communicate with contractors as well. So, but if we are talking from the experience perspective and what we've came in here in Ukraine, like advising IT companies, they are not bothering with the effectiveness because they're creating tasks and they're creating the deadlines for their tasks. So this is the responsibility of the employee or the contractor to perform within these deadlines. And this is like the KPI, key productive points that they are interested in. So usually these meetings are quite short, just not to make this very ineffective. This is the first point. Usually they take up to 30, maybe even less, up to 15 minutes, just to share the information among the team. But on the other side, they do these meetings regularly. So, for example, they meet each week, depending on, of course, depending on the group and depending on the tasks. But usually they decide to meet oftenly if they do not work within the single space. If they work distantly from home, so they meet like every morning, and they meet like for 15 minutes, exchanging their thoughts and their progress. So this is like the basic and the most effective advice in current situation, I believe, without touching any other legal options and other surveillance technologies, etc.
Well, I agree. That's what actually I'm implementing and try to make it as short as possible. So any video conference call longer than 40 minutes would turn into something ineffective. That's what my experience shows. So we try to make it also, as you mentioned, often and short. That is more efficient rather than make it, more seldom and long. Well, yes, I support that. And thanks for offering the next week webinar. So we'll check into that. Thank you.
So, dear colleagues, if you have any questions on the matter we discussed during this online session, you're very welcome, because we have about 10 minutes for it, and our speakers and participants will be really happy to answer to all your questions, or maybe you have some ideas or practical experience to tell us about video conferencing in your daily operations of your business during these challenging times. Thanks.
So it seems there's nothing to ask about this, about the issues we covered. I have actually one question that troubles me all the time, is what to do with the security issues if you're dealing with the strictly confidential information. And what I'm bothering is that in modern times we're using mostly software technologies, rather hardware technologies, and it is rather hard to control what updates or what changes the developer or the owner of this software makes. So is it necessary? Is it actually necessary to make sure that every update will not break your security prior installing this update? I'm talking this from we actually in Ukraine had a bad experience when the program for accountants actually was hacked, and due to when next update arrived and was installed, actually all those computers became infected, and that's an issue whether the IT contractor or IT service provider or your own IT department should actually check any updates or any kind of new software before actually installing this and going live. So maybe anyone can have some thoughts to share about that.
I can answer from the technical side to this question. I think in every effective organization there must be an information security department, and when any software project releases an update, there is a set of documentation called release notes, which defines what changes actually this update will take to the system. So the first tip is to review it carefully. And the second tip is that when before updating and make it productive, it will be good to test this update in a virtual environment. So the test virtual environment must be present for these tasks, I think.
Okay, thank you, Anna. Thank you, colleagues. We have time to close our meeting. So I really appreciate your efforts of connection with us and sharing experience of teleconferencing in your jurisdiction. It's really a great experience for me to moderate this meeting, and I really thank you for joining, and hope that you'll participate in the further meeting we'll have in our IT and Cybersecurity Committee here. Okay, thank you. And if you have any questions, I guess you can turn it to the speakers here, or just in private communication via emails or con calls. All details will be provided you after the meeting. Okay. Thank you, and stay safe during this time.
One minute, please. I just wanted to add and to say thank you once more from Germany Ukrainian Chamber of Commerce, and to all of our speakers, to all participants, and our conference online discussion was recorded. And if you want, if you have some need, I can share this video with you. And by the way, it's the short overview will be posted on our website of OHK Ukraine. So welcome, and thank you once more for your active position, for your change of experience. Thank you.
Thank you, Tatiana. Actually, thank you both of Tatianas for organizing and moderating this meeting. It was a pleasure, and we were very glad to exchange our thoughts and experience within this committee.
Okay, thank you. So I wish you stay healthy, and you and your families, and be full of optimism. Everything will be okay, I'm sure. So have a nice day.
Thank you.
Thank you.
Thank you, everyone.
You too. Bye-bye.
Bye-bye.